Hey guys, welcome back. I wonder why it didn't redirect. It was set to. It said I saved it even 11:25. So if you hear a echo, it's because the little one turned my stream on her iPad. So hey everyone. It's weird how I was just on a stream for 2 hours and had at most 33 people, and all of a sudden I put what the Hales in a stream and I have 58 people here. How YouTube's going to YouTube. Yeah. So it's just weird. See, that is not me, that is her. That is her. Angel, can you go to a different thing besides watching mommy? See, this is not me. This is baby squid saying hi. Yes, that's mommy, isn't it? Can we go to a different thing besides putting in? She's kissing the iPad. She's giving mama kisses. It's so stinking cute. Yeah. So I will unban anybody that gets modded. Yeah. Welcome to my drama. Hey, we're gonna go this way. Here. What? We're gonna close mama's stream. There we go. Now you can start. You can start over. Blame little one. I'm literally right here. Yep, we went over the documents for Dr. Joe's lawsuit, and the fact that the defendants there was a motion for TLDR, there was a motion for judgment because they didn't respond to the state court, and now they are trying to move it into federal court. I'm going to look up the federal court on Pacer, see if anything was filed by Dr. Joe, and get back to you. However, at the end of that stream, FlashFan reminded me that that something might have been out, the Stark's deposition, and I forgot that was in the state court. So instead of looking at the state court, I looked at Pacer. Well, there is a new document on Pacer that wasn't here at 8 o'clock this morning when I checked, because when I was in Mo's chat, I was on Pacer at the same time. And thank you, Ung Hung here, for the $2 super chat. Oh boy, what Deuce Foreskin do now? We will see. I did download this, and I like to open it in the PDF form because it's so much easier to manipulate, and if I need to redact it, it can redact it. It's only 7 pages long, so it should be relatively short if he wrote it like an attorney should. And do you notice how he does not put Gainesville Division, like Shockett and the judge? He fails to put that in. It's almost like he does it on purpose. Yes. Oh, let her type. It's too cute. So I was on. I started my stream this morning at 9:15. So this is a new stream. Over under on it will be intelligent. I'm gonna go with a no every time. She does tend to time people out. She has done it before. To a couple of people in Megan's chat one time. I felt so bad because she tried to grab my phone and it was like, oh, you're timed out for 24 hours. Like, great. Good morning, Lady Jan. How are you? All right. This was filed this morning. It was not here at 8 o'clock. So sometimes between 8 o'clock and now. Motion for extension of time to disclose rebuttal expert. The defendants move for an extension of time to disclose a rebuttal expert until 30 days after the court issues its impending ruling and decision on the defendant's motion for summary judgment for the plaintiff's defamation claim. Here's my thing. Right off the bat, when he wants to extend time, whether his extension of time is valid or not, my brain always goes to, he always wants to stall. So my brain initially goes, why is he stalling now? Like, yeah, he probably filed it at 4:59 p.m. so it wouldn't show up until today. And that's a really good point too. It's just, I look first thing in the morning, and I looked, 10 minutes ago and it was there. I'm like, oh, So this one is thanks to FlashFan. Federal Rule of Civil Procedure 6B provides, Quote, when an act may or must be done within a specified time, the court may, for good cause, extend the time on motion made after the time has expired if the party failed to act because of an excusable neglect. Although FRCP 26A2D2 gives 30 days for disclosing a purely rebuttal expert following the disclosure of the plaintiff's expert, footnote 1, the defendants have been awaiting the outcome of their summary judgment motion on the plaintiff's defamation claims before determining whether they would need an expert at all. See, this to me is like is wrong on every sense of the like you should be searching for an expert. You assume the case is going forward so that you are prepared for any. It's hoping for the best, preparing for the worst, hoping that the summary judgment is granted, hoping the case gets thrown out, but preparing that it's going to go forward. So this to me is just him not being prepared. This to me is just you didn't do your due diligence as a lawyer. Therefore, the defendants not having disclosed a rebuttal expert within the time limit under FRCP 26A2D2 is due to excusable neglect and thus should not preclude the rebuttal expert disclosure. I did not. I have been in front of my computer since about 8:30, other than doing mama stuff. Footnote 1, time to disclose expert testimony absent a stipulation or a court order. The disclosures must be made. 2, if the evidence is intended solely to contradict or rebut evidence on the same subject matter identified by another party under Rule 26A2B or C within 30 days after the other party's disclosure. This is, to me, just reading this is you didn't do your due diligence as a lawyer, and now you're trying to blame or you're trying to find an excuse for it. What that phrase most of us were taught, hope for the best, prepare for the worst. You hope that you don't have to hire an expert, but you still look for one in the event that you have to. To me, this is just a failure of a lawyer to do their job. Like, I would say the same thing even if it wasn't Bubbles. I would say the same thing about any other lawyer. Hey, John, how are you? Like, the judge already said he was not granting a summary judgment, and there's the other point. Oh, but didn't he say that in a footnote? So it probably wasn't read. Factors relevant to allowing an expert are, quote, explanation for the failure to disclose the witness, the importance of the testimony, and the prejudice to the opposing party if the witness had been allowed to testify. Romero v. Drummond Company, 11th Circuit, 2008. A party's failure to make timely expert disclosures is harmless if that party shows, quote, there is no prejudice to the party entitled to receive disclosure. LaMonica v. Hartford Insurance Company of the Midwest, Northern District of Florida, 2020, citing Taylor v. Mentor Worldwide, LLC, 11th Circuit, 2019. See also Hewitt v. Liberty Mutual Group, Incorporated, Middle District of Florida, 2010. That's a good point. I'm definitely not going to get into that because I did not, like I said, I don't pay attention to anything but filings, and that was before anybody started threatening me. So that was before I started covering this case, and I heard about it, but I did not care. So I tuned it out. I remember slightly, but I did not. Yeah. Hey, Wendy, how are you? Wenderbender. I love that name. When Lynette no longer wants anything to do with Deuce foreskin, is that actually a circumcision? I don't know. 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 Like, I just there's certain things that I just don't want to think about. But I think I think my dad one time when Bruce was in chat did tell him to go get circumcised. So I you could take that one as you will. I'm not really sure what any of that means, but we shall see. Oh boy. Like had to go into something. Oh. Although a motion for an extension could have been filed sooner. No shit, Sherlock. Whether before or after 30 days from when the plaintiff disclosed their expert, footnote 2, there is no imaginable prejudice to the plaintiff if an extension is granted now as opposed to a few weeks sooner. Because whether granted sooner or now, the extension would be the same if it is to have any meaning, until some period following the court's issuance of its decision on the summary judgment motion. Didn't he already say in a footnote that he was not going, that this was moving forward? Ugh. Sorry, this is just like, it makes me think that Bubbles doesn't actually read anything. It does. Like it, or he thinks he's above what the judge already said. Like he's going to change the judge's mind. Does that mean he's an asshat? I mean, not. Would your medical diagnosis be cranium rectal inversion? I'm not a doctor, but that sounds like a good, yeah. Rumor has it the two fleas on the way out of the PR business. Douchemanskin don't like it there. Commitment to the cause. Hey, Craig. Oh, I love this chat. Y'all are so much fun. Like, and hey, Bingo Bertie. Oh my god. He just seems to open his mouth and insert his foot all the time. Do your toenails taste good? Like, I hope they don't have any fungus on them or anything. Just that allows the defendants to rely on that decision in determining their expert witness needs and acting on them. You should always be prepared for things to move forward. Should always be prepared. Think of it, Bruce, as a snowstorm. You're always prepared for a snowstorm, whether it actually happens or not. If you're prepared, be a Boy Scout. You were never a Boy Scout, were you? Furthermore, the default time limit under Rule 26A2D1 is 90 days before trial, disclosing a rebuttal expert, and the defendants would be disclosing a rebuttal expert long before that temporal threshold is reached. There is thus no prejudice, and the request extension would be harmless. Footnote 2, the undersigned is not certain of when the plaintiffs disclosed his expert because the expert disclosed itself has no date nor any certificate of service. See Exhibit A attached here too. The defendants, on the other hand, would be prejudiced if the court were to strictly enforce the time limit in FRCP 26A2D2 because it would leave the plaintiff's expert unopposed. Well, whose fault is that you were not prepared? That is not the court's fault. And this one, you can't blame Jeremy because this is a you problem. So I heard that this deposition transcript might be out. I made the mistake of going on to Pacer when I was talking about that, and I found this. So it's one of those. I'm excited to read that. The thumbnail case is very interesting to me in the sense of it affects, and it could affect all YouTubers. So it's kind of interesting in that sense. The defendants might have been able to disclose a rebuttal witness sooner had they known that they would need one due to their summary judgment motion being denied. You don't read footnotes, do you? I think that's one of his judgments he made in a footnote. Hoy. Hey, Janice. Getting in the shower, so I'll be listening but not participating, which is good since I have nothing nice to say about Momo's stupidity. Ah, just dumb comments just make me laugh. Like, just make me laugh. Although the court revealed it will deny the motion in its January 17th order, denying the plaintiff's motion leave to amend. Okay, right here. Bruce never put in a motion that the judge already said he was going to deny it and remind him of the fact that he already made this decision. He already made this decision. Hey, King Paco, how are you? We are good. I actually have internet now and it works. Cross your fingers. I've been Amish all weekend. No internet, no cell phone service. Hey, Roslyn. Never put in a... Look at this. Although the court revealed it will deny the motion in its January 17th order denying plaintiff's motion for leave to amend. That right there should have told you. That right there should have told you. I need to search for an expert. I need to search for an expert. I have nothing nice to say right now, so I'm just taking a pause. I have a lot of problems with that statement. One, never remind the judge that even though he hasn't written a formal order, he did put in a different motion that he was going to deny your order for the summary judgment motion. Two, oh my God, I'm losing brain cells. Never remind him. Never remind him. Never let him know that you know that he is going to deny it. Never remind him of the fact that you should know that he is going to deny it. You look unprepared. I see this getting denied just based on that statement alone. Without the benefit of the written decision and the court's reasoning, the defendants are prejudiced with respect to being able to determine their expert witness needs. No, you prepare as if that motion is going to get denied because the judge already said he was going to deny it. Just because he hasn't written his formal order doesn't mean you get to assume that he's going to throw this case out. I just can't. Just can't. I think BBB is used to getting in his way by threats and not actual litigation. Yeah, and he's getting in his own way. Hey, you. What are you making over there? Local Rule 6.1 provides that the parties may stipulate without court approval to extend a deadline for responding to a specific discovery request or for making a Federal Rule of Civil Procedure 26 disclosure if the extension does not interfere with the time set for any of these, completing discovery, submitting or responding to a motion or trial. There will be no interference with completing discovery, which closes April 7th. There will be no interference with trial, which is scheduled for August. There will be no interference with the dispositive motion to deadline of April 28th, by which the defendants expect to file a summary judgment motion on the remaining claims. Footnote 3. The plaintiff's counsel nevertheless refused to stipulate necessitating the present motion. Yeah, I don't know. I don't know. Yeah, we dislike BBB, but we're polite about it. I tried to use his actual words in documents to justify why I don't think he's a good lawyer. and not his comments elsewhere. Because his comments elsewhere are his personality, which I still don't like, but his competency as a lawyer, I am making my assumptions on what I see in the filings and what I don't like about the filings. It's good. Not saying Bubbles is stupid, but I know ABs and AOs that show more intelligence. I know at least 2 AOs that show more intelligence. One lives with me. I just footnote 3, the defendants will rely on the plaintiff's admissions, deposition testimony, and document production, showing the plaintiff A, cannot establish publication or damages to overcome summary judgment on defamation based on the roadside signs, B, has produced no other actionable defamatory statements of the defendants about him, and C, has no evidence the defendants did anything to tortiously interfere with the plaintiff's business. I see this, not only watching a handful of Jeremy's videos at best, calling someone's business like partners and making phone calls of why they shouldn't do business with him, that just to me tells me straight away that you're interfering with business relationships. The court stated in its January 17th order that it was advising the parties in advance of the outcome of summary judgment for planning purposes, and so the present motion is intended to resolve the issue sooner rather than waiting until after the summary judgment decision to move for an extension. You should have already had your witnesses lined up, and or be searching for an expert witness because you knew that he was going to deny it. This right here makes me think that he can't find any expert witnesses that agree with him. And because those expert witnesses have nothing to be paid with, expert witnesses like their money. Expert witnesses are paid to be there. If you have nothing to pay them with, they are less likely to help you. Not saying that all expert witnesses are there for the money, but no one likes to work for free. So, yeah, no one likes to work for free. Oh my God. Oh. Granting the requested extension will enable the defendants to complete the process of retaining and disclosing a rebuttal witness expert as promptly as possible following the issuance of the summary judgment decision, perhaps sooner than the requested 30 days from issuance. The court should consider that if faced with being precluded on timeliness grounds under FRCP 26A2D2 from disclosing a rebuttal expert, it would be necessary for the defendants to assert a counterclaim alleging that the plaintiff wrote the very defamatory road signs allegedly written by the defendant in the plaintiff's complaint. Duh. This is basically a threat for a counterclaim if they don't get the extension. That sounds like a threat to me. I don't know about y'all, but this few sentences right here, or this sentence, sounds like a threat that if you don't extend this, we are going to file a counterclaim. Oh, thank you. You want to come up here? Okay, come on. Oh, you can have it. You can have it. It's right there. And poor Marine, thank you for the $20 super chat. Sorry to be late with reading rumors on Bookface. Oh yeah, like there's some interesting. Well, I don't ever go on Facebook. Facebook is my private thing with my friends and my family. Like I don't ever. I have a Squid Facebook page, but I barely post there. This is a claim the defendants might otherwise reserve for a separate action against the plaintiff by the present defendant and defendant Preston's minor child, basically threatening more litigation. I don't know why you would want to do that in a legal filing that the judge is going to read. I don't understand why you would want to threaten another lawsuit. Bringing the counterclaim in this present action would mean the defendant's expert disclosure would not be strictly for rebuttal. The defendants didn't write the signs, but would also be to affirmatively establish the defendant's entitlement to damages. The plaintiff wrote the signs to frame them. The 30-day time limit in FRCP 26A2D2 would therefore be completely inapplicable. Footnote 4. The undersigned offered to stipulate not to counterclaim in the present case if the plaintiff's counsel would stipulate to the defendant's rebuttal expert beyond the time in Rule 26A2D2 asking, will you agree not to raise any timeliness issues with our expert disclosure if we agree not to bring a counterclaim against your client based on our expert's conclusion that he wrote the signs? So you threaten again. You give them an ultimatum of a counterclaim, of another lawsuit that would drag this out even longer, that Lynette cannot pay for because she's a hardship, as you keep referring to. Oh my goodness. Yeah, don't punish me for missing the deadline and I won't sue. Yeah, that right there. Like, don't. Oh my God. You know, he was just waiting on the written decision. He will then write a response to enlighten the judge on the errors of his thinking. Yeah. I just this has entitlement written all over it. I don't know why exactly, but reading this makes me think he is entitled. Like, he's giving that entitlement. Yeah. Another funny thing is Pensacola is Great Place Naval Air Station, beaches, and even Gainesville has nothing except discount stores and a junior college of Florida Gators. Discount. Poor Maureen. I was supposed to go to Pensacola for school, but Hurricane Ivan hit in September of 2004, and that screwed up the whole timeline of my career. Yeah, and then there's this. Like, I don't know exactly that expert. Like, there was a whole drama with that, and I watched it a little on Shizzy's channel, and I watched Megan talk about it a little, but that was before I really started getting into this. Because I thought everybody sucked. As y'all know, I thought everybody sucked. So I'm like, I'm staying out of it. But then someone who shall remain bubble-brained, allegedly, trolled me, threatened my daughter, laughed about my daughter possibly choking. So I am doing this out of spite. So I knew that they had one. I just don't know his thing. I hope Jeremy's lawyer raised that 2 fleas have already been sharing their expert, so there's no need for an extension. That is also a good point. That is also a good point. And so let me get this straight. His expert is claiming Jeremy wrote the signs himself forging LP's writing to frame her. Make it make sense. Yeah, that's pretty much it. That's what I'm getting from it. Because late disclosure is due to an excusable neglect, because it would be harmless to the plaintiff, and because denying an extension would prejudice the defendant. Dude, proofread. It's supposed to be the defendants, not he defendants. Oy vey. The court should grant an extension to disclose defendant's rebuttal expert for 30 days following the issuance of the summary judgment decision. No, sorry. You literally said, and this is Exhibit A. See, look how everybody else in their orders and their filings say Gainesville Division. And dude, Exhibit A, you type up a page with Exhibit A. I'm going to I'm looking up what we just went over in my last stream, before I knew that there was a this right here. You type up. We are going to stop this for a second, and we are going to share, just in case Bubbles is watching. You can see how to do something properly. This is from the Hillsborough County, which is also in Florida, Tampa area, you type Exhibit 5. And then when you have another thing, Exhibit 2. You don't write Exhibit A on the top of a piece of paper. You don't write Exhibit A on the top of a piece of paper. You just don't. You just don't. You don't do this. You don't handwrite anything. Ugh. Yeah, I've heard that, and that's an easy, like, provable fact. And that's the other thing that I like. There's just so many things wrong with this. Plaintiff's disclosure of expert testimony. Plaintiff Jeremy Bryan Hales, by and through the undersigned counsel and pursuant to Federal Rule of Civil Procedure 26A2, hereby makes the following disclosure. Expert witness Diane Peterson, certified forensic document expert. The disclosure is based on information. She spilled my cup. I just needed to make sure we didn't get water all over. Yes, this is brand new. I was actually talking about another case, and I was just about to end my other stream right before this when I checked Pacer and this document popped up. So we redirected to myself. And so I had another stream earlier this morning about Dr. Joe Corcoran is suing HCA Healthcare. And there's been a bunch of documents that dropped in that case that we just hadn't gone over. And then we just redirected sort of to ourselves. This disclosure is based on information presently available to Mr. Hales, and thus Mr. Hales reserves the right to amend and or supplement this disclosure as discovery and investigation continue. This disclosure is made without waiver of any applicable or potentially applicable privilege or work product protection. This disclosure is accompanied by a written report prepared and signed by the witness statement and the compensation to be paid for the study and testimony in this case. And this one I do. Okay, strictly a call it like I see it. I do agree with Bubbles in the sense that there was no certificate of service and wasn't signed by anybody. But that still does not excuse him from not being prepared in his own case. So So that does not excuse him from being unprepared. This is where Bubbles loses the plot, in my opinion. So he wasn't even in Florida, but was in Ohio. Yeah, and that's a provable fact. Like, that was before I started covering it. I've heard that. But, Bubbles filed this. I want to say this is probably the dumbest motion I think he's filed. Because he literally says in this, the court stated in his January 17th order that it was advising the parties in advance of the outcome of the summary judgment for planning purposes. And so the present motion is intended to resolve the issue sooner rather than waiting until after the summary judgment motion or to move for an extension. He already told you up here, he puts, although the court revealed in its Although the court revealed it will deny the motion in its January 17th order. So you already knew. You already knew that he said he was going to, he already said that he was going to deny it. And that makes you unprepared. That is not the court's fault. That is not Jeremy's fault. You cannot blame Jeremy for this one. Hashtag can't blame Jeremy. You can't blame Jeremy for something that you are unprepared for. You can't file a motion for what you are unprepared for. He is trying to extend the deadline. Federal Rules of Civil Procedure state, the Rule 26, A2D2, says that you have 30 days after the filing of the motion to, Local Rule 6.1 provides the parties may stipulate without court approval to extend a deadline for responding to a specific discovery request or for making a Federal Rule of Civil Procedure 26 disclosure. So he wants an extension of time that they can search for a handwriting expert, which, one, they already had one, supposedly. Secondly, they already had one. Thirdly, he knew that they were in the January 17th motion that the judge was going to deny it, because the judge literally said, I'm going to deny this motion. I just haven't done it yet. So this right here makes me think that he is the worst. He is the least prepared lawyer I've ever seen file a motion. And that's saying a lot, because even Carly Gregg's lawyers, who were not unaliving trial lawyers or criminal defense attorneys, still filed better motions than this. I didn't agree with their reasoning, but how they filed it was they actually tried to make valid points. It just... Oh, yeah. And King Paco, thank you for the $2 super sticker. I appreciate you. Oh my God, this one made me lose brain cells. Does anybody else feel like this is just the most ridiculous motion they've ever seen? Right now, I am going to look, because I was also told about, down please. Thank you. We are going to go to County Clerk's website, Levy County. I am looking into, Jeremy's new short is devastating to Bubbles. I will have to check it out after here. Online court records. Levy County. God, Florida makes it so much easier. Big thank you, Squid, for popping in again. Well, we had some time before alternate juror stream, and it was one of those, like, it was just one of those things. It was like, we had it. Hales. Jeremy. Let's see if I can find this easy. This is not as... Levy County is not as easy as some other the view selection. This is proof your supports not for subject. Oh no, it melted. I told you it would melt. I have an Elgato wavelink. She carries my Blue Yeti. The Blue Yeti was causing issues with my it would make my computer think that it was working overtime, and it did not go well together. Blame Jeremy. Do not blame Jeremy. Yes, Dark threw Bubbles under the bus today. I heard that the I'm looking at the county clerk's website, and I just can't. There we go. This one. There we go. Judge Davis. Levy County's site is not the most it's not the most, let's see, easily accessible or set up, because I'm on the Clerk of Florida's website. I went about it a different way, and it's not the easiest way to read. So there is nothing in there yet. There was the notice of taking deposition on the 20th, and that was the last thing. Well, it is a college town, so this is what we got going on. This is the last thing that was in. Scott Stark, 1:27:25, 10 a.m. on Zoom. So we shall see what it says. So when there is something in, I will let you guys know. it's just going to be, it's just a purely, it's just, when you think it can't get any more ridiculous, it gets more ridiculous. I just don't understand it. Like, why does it get more ridiculous? Angel, why does it get more ridiculous? Yeah, it's not very user friendly. Thank you for those who put the words that I was trying to think of. It's been a day. I am back from being offline. Not having cell phone service or internet service was hard, and there was no there was not the it's weird because there was not the like, usually when your internet doesn't work, fine, you have cell phone service, but we didn't have cell phone service either. So not having cell phone service, I couldn't do anything. I couldn't even communicate. Yeah. Little squid says, "Oh, can't wait to see how this all plays out. Thanks for giving us a safe place to watch and not play on all this ugly. We can't be there in person. Get the facts. Next best." Thank you, Common Sense. My video is not matching with my voice. Oh no, it could be my internet. Yeah, at least we had power. Yes, we did have power. There are still people in Florida who don't have power from Hurricane Helene and or Hurricane Milton. So I posted a video that Rosalind Duke made on my Twitter. She is going into people's individual stories from the hurricane. Get off the table. Come here. Come here. Come here. Oh my goodness. Whoop. Well, that's what we get for being on the table. Oh, okay. Doop. And we need to change your pants because you spilled water. It's me. What are you doing? All right. I am not in Florida. I am in Georgia. But we were hit really hard by Hurricane Helene. I did actually, off the table. You know you're not supposed to be on there. Mama duties. Be right back. Sorry, she's now having a meltdown. We are going to look at. I need to go give her lunch. Yeah, baby squid is that her new favorite thing is to climb on the table now. I've literally given birth to Evil Knievel. She got a new bed the other day. She got a new bed. She got a big girl bed. Well, here's the thing about a big girl bed. Her new thing is she likes to jump over the rails on her big girl bed. She flips on the couch. She flips off the couch. And you can't tell her no. We're in kind of FAFO mode. After telling her no so many times, she is we're just gonna have to learn the hard way. Like, I just can't tell her no anymore. She's gonna have to understand. I tell her no. I know, but telling her no is like, she thinks that it's like the most evil thing in the world. That's what is weird to me, is like telling her no is like the end of her world. Yeah, telling you no, like you're not. It's in there. Go get it. You can go get it. I'll get it for you. Well, you can go get it and I'll open it. All right. But it wasn't Lamette that made the phone call. It was Deuce. Yeah, I know. It's like my mama heart is like, I know that's the only way that she's going to learn. However, I do not want to see her even get a bruise. It's my mama heart going, I know she needs to learn that way, but it's so hard to like, Oh yeah, she's my adventurous. Like, yeah, climbing everything. Like, the judge should allow Bubbles to be added to the federal lawsuit. Well, I understand his reasoning for not. I am keeping a close eye on Pacer and searching Jeremy Hale's name on Pacer to see if anything else pops up. If she gets married in 45 years, I won't be there because I probably won't be alive in 45 years because that will make me 85 years old or 84 years old, and I will lucky if I make it to 65 at this point. So I am going to get going. I have to give her lunch and I have to change her pants because she likes to take my. Yep, this was filled full this morning. It's not full now. So she spilled it somewhere, which means I have to go clean up a water spill on the floor before she falls in it. So if, yeah, I know, but it's just so hard. Just so hard. Just so hard. My daughter had a 2.5 twin girls and a newborn. She's two persons and a climber, so she's potty training. Yeah. One day we're ready for potty training, and the next she wants nothing to do with it. Get down. Get down. Don't smile at me like that. I know you're stinking cute. Get down. Just because you're super cute doesn't mean it's any better. All right. I have to get going. I have to take my 2-year-old, get her lunch, and make sure she doesn't break her neck on the table. So, y'all, oh, yeah. As soon as she's potty trained, we're moving to a bigger town soon. Hopefully sometime soon. And we will probably be doing a mommy and me class at the gymnastics gym, because that way she can learn to control her body, because right now she has no proprioception and she throws herself and things don't she doesn't know where she's throwing herself. Like, she'll do a somersault into the wall and it's like, oh, why did my legs hit the wall? It's like we're going to figure out, we're going to have somebody else that's smarter than me in that area teach you how to control your body so you can do these things without getting hurt. Y'all have a great day. I'm going to redirect to alternate juror. Hopefully it actually works this time. And I will see you guys on the next one. I might stream tonight, just a whatever stream, just to help me get back into not streaming for 3 days. And I have a lot of work to catch up on, because no internet means I can't download documents and I can't research things because I have no internet. Y'all have a great day. I need to get Crouching Tiger off the table. I love you guys. Make sure you hit that like button. I do a whole lot of other cases besides What the Hales. I would really love, I know this is the hot button issue right now, but I would really love for you to join me for like Maya and Dr. Joe. We are on Wednesdays going to start streaming the Navy vet versus CNN case that just had a jury verdict a couple of weeks ago or last week. It should be an interesting time. I do more than just What the Hales. I'd love for you to hang out with me then. Bye, guys. You want to say bye? Say bye. See you.